I want to first go across on the legal implications of today's verdict. It's a historic verdict in many ways than one. Mahesh Jethmalani, senior advocate of the Supreme Court, is now joining us. Mahesh, thank you very much for speaking with us. But first things first, so quota within quota. There have been judgments in the past where the Supreme Court has frowned upon that principle. Today, the Supreme Court has said that subclassification is a necessity amongst reserved categories. It is possible. It would be erroneous to consider that all SCs and STs are homogeneous or integrated, and that subclassification, just like for OBCs, there is an identification of creamy layer, there has to be an identification of creamy layer for SCs and STs. How do you view today's verdict?
Well, I view it as being unacceptable. I mean, nobody can take objection to what the Supreme Court has held. Quota within quota or subclassification, which is the same thing, is necessary for the purpose of, including groups, bringing into the reservation category people, those castes which have not got the benefits of they are not adequately represented in getting the benefits of representation. So certainly it's unacceptable. The whole idea, as Justice Gawai said, was to attain true equality. So if certain scheduled castes or scheduled tribes are being left behind in getting the benefits of reservation, you can make a sub-classification based on empirical data that these subcastes are in fact, or the group which is to be subclassified, they are in fact not getting the benefits and they deserve further advancement, and therefore they should be subcategorized to get the benefits which they are so far being deprived of, based on empirical evidence of that need.
Okay, so there are two arguments against this. One is, again, I go back to the E.V. Chennaiya versus State of Andhra Pradesh judgment, the 5-judge bench, which said that in the case of discrimination against SCs and STs, the need for reservation for SCs and STs was based on their discriminatory status, essentially because of social standing and their social and economic or educationally backward status, which is not the case for OBCs, where you've identified basis an economic parameter, which is 8.5 lakh rupees annual income. If you're above that, you're creamy layer and therefore you are removed from the benefits of reservation. So you can't apply what is the yardstick for OBCs and identification of creamy layer. You cannot do that for SCs and STs. The second objection is that the same court, in the case of Dalit Christians and backward caste Muslims, which is frowned upon quota within quota, how do you justify quota within quota in this instance?
As I said, in this instance, you're justifying quota. Again, if you read the judgments, right, you are actually justifying it because the purpose of reservation is to bring people up to a livable standard, to give them the fruits of reservation. So if there's a particular group which is not getting that reservation, you create a sub-classification and afford them that. Now the old judgment, Chennaiya, right, which actually is frowned upon this and which has now been overruled, was based on a construction which the Supreme Court today didn't agree with. It said that basically the states couldn't do the sub-classification because it was a power reserved exclusively under Article 341 for the President.
Yeah.
The Supreme Court today has said that this is a misreading of 341 because 341 only empowers the President on the advice of the Governor of a given state to specify castes who will come within that list for reservation. But it is not the source of the power of reservation. That belongs to Article 15 and 16. So because that was a misconstruction, and Chennaiya held that since it was exclusively the President's prerogative under 341 to do so, and therefore it was frowned upon in that judgment, it was held to be unconstitutional. The Supreme Court's construction now permits subclassification within the reserved class, the quota within the quota.
Okay. All right. Mahesh Jethmalani, thank you very much for joining us and explaining the legal nuance around this and why today's judgment is historic in many ways.